The greatest leaders in business look for the emerging stories in their organization and use the data to choose their preferred outcome. What outcome do you want in your business? Listen to the stories of industry veterans, coaches, and consultants so you can choose your preferred business outcome. Hey, everyone, and welcome to the brand new episode of Business Blind Spots Exposed. You know, it used to be that I used to think my effectiveness and my greatness as a leader was going to come from how smart I was. Yeah, and I started to get a little bit older and wiser and realized that I wouldn't be able to keep up with my 50 best friends because they were all as smart as me, hopefully, if not more. But if I kept them as friends and I kept picking their brain for ideas, they would start teaching me stuff faster than I could because they spent 25 or 30 years doing it, and I could just pick up the phone call and find out in 10 minutes. Gosh, that is power in my mind. So this whole podcast is dedicated to the idea that there's these blind spots that I have because that's just not what I've learned. So can I get the experts? Can I get the veterans, the grizzled veterans, the people who've been there and done that to distill for us what you need to know so that you can get rid of your own blind spots? And today I've got Devin Miller with me. Hey, Devin, how you doing today?
Oh, I'm doing wonderful as ever, and appreciate you having me on. Excited to chat.
Yeah, I want to do a little bit of housekeeping before we get started because I'm really excited about this conversation with Devin for a number of reasons. In a few days, I've got Jeannie Hoffman, and she's going to be talking about employee buying equals process certainty. This is the whole idea that if you have process in your company and you have employees buy into that process, you're going to create more equity and more value in your business. I expect you'll get a lot of good nuggets out of that. Please do tune in for that. But today I've got Devin Miller, and the topic that we decided on was protecting and growing one of your biggest assets as an entrepreneur. A lot of people think about a business as something that you just start growing. And I think we're going to get into some details here, but you just start growing. But over time, you start building all this value, but that value deserves some level of protection. You've taken time to build it all. And not everybody can, everyone's worries about being in a place where the competitors can pick up and do whatever you want. Well, you can make it a little more difficult for them to just pick it up and do it for a lot of reasons. And I think that's where we're going to get into a little bit of today, aren't we, Devin?
Absolutely. No. And I think that's a great spot. And I think that, it's oftentimes overlooked. People think, oh, I'll out-compete or, there's nothing to be done or any number of things. And I think there's a lot more strategy and a lot more thought that can go into it. So yeah, excited about a great conversation.
So let me tell you a little bit about Devin, a little bit, just so you know a little more who he is and why I wanted to bring him into the podcast. So his title is CEO of the Miller IP law firm, does patents and trademarks. And here's a couple of things from his bio. Loves startups, and if you kind of haven't figured that out from the sign on the wall, he runs his own patent trademark law firm that helps startups and small businesses. He also started his first startup early on himself in his career while earning his law degree and his MBA. So 4 degrees in total, which is impressive in and of itself. Since then, you've founded several 7- and 8-figure startups and enjoyed every minute of it. So broad diversity of experience, a unique perspective in terms of how you bring expertise to the table in and around this idea of IP and intellectual property. So I think there's a lot there that people don't spend a lot of time thinking about until they think only you get to a really big company. That's when you need IP and all this kind of stuff. I think that starts much earlier on. Is that a fair statement there?
I think it is. That's certainly a fair statement. I mean, I think that by the time you're a big company, you should already have had that in place. And, even if you're a smaller company, there's a very oftentimes a good justification for why you'd invest in it. Because if you think about it, intellectual property at its core is kind of similar to real property. In other words, you can own real property. So you can own a house, you can own land, you can own a building, you can own vehicles or whatnot. and they have some real value to them, and that's hence why you own them. You want to have that ownership and that investment in them, because oftentimes, like what, maybe not for cars, but everything else. And with that, same thing with intellectual property. As you're building a business, as you're building a brand, as you're creating and inventing things, as you're doing other things that build value into your business, a lot of that is intellectual. It's less tangible. It's not as physical, and yet it just has as much value. And so if you're kind of just neglecting that or avoiding, or, overlooking it, then you're going to miss out on creating a lot of that value and capturing a lot of that value of your business, such that as you're getting bigger, as you may be looking to, whether it's franchise, whether it's bring on investors, whether it's, fend off competition, whether it's, or set yourself up for acquisition or for mergers or anything, the more you can capture that value, the more you're successful in your business. And so I think that's a great introduction.
So, I mean, I was telling you about this podcast we're going to do about this whole idea of getting employee buy-in into your process builds equity in your company. I mean, and let's talk about that word equity for a little while, right? Equity is the value that you built in your company. And lots of times a process, if the owner can go away for 3 weeks on vacation without answering any phone calls or anything like that, that shows you that the process is working. And what I'm hearing from you a little bit, or kind of I'm leaping a little bit forward here in the conversation, and this is where I want you to kind of maybe dispel the myths or educate me a little bit here, is if I can take a process and say, that's mine, nobody can take that from me. And if an investor or even an employee wants to come and take a look at it, or a partner wants to come and take a look at it and say, this is a proven process and it's mine and nobody else can touch it. There's value for the employees, for the investors, for customers, for partners. Everybody gets some value out of it because you can say, that's mine. Is that a fair way to look at that?
No, I think so. And I mean, I think that, so there are kind of the short answer is yes. And I think there are kind of two reasons typically why you're looking to protect your intellectual property, whether that's patents, trademarks, copyrights, or other things. And one is you're saying, hey, if I'm putting all of this time, money, and effort, blood, sweat, and tears into developing something, I want to be able to own it, and I want to be able to have it protected. And otherwise, if somebody else can come along and grab it and copy it or mimic it, I just lost out on all that blood, sweat, and tears. And it's kind of like the magic show where once you know how it works, the magic, or once you know how it works, it's easy to replicate. And so you're saying, hey, this is mine and I put all this effort. I don't want somebody just to come and copy it. And so it's kind of a defensive posture, and it helps, motivate the employees, know that there's an ownership, that people, that you have something that after you put all this effort into it, that is yours or is a business's. And the other one is also that tangible asset. In other words, it's an investable asset to where you're saying, hey, this is actually creating value. It can be of value. It's an investment of the business. And now we have something that we can capture that value such that it is actually going to help the business to grow. And so I think it's both on the defensive side of helping to capture what is yours, but also on the offensive or the investing side of capturing the value for your business.
So I always like to think in terms of takeaways, and sort of distilling in my head. So what I liked is you said that there's two sides to it. It's not really just always defensive. It could be the offensive side too, right? Growing in the value, scaling your company. Now, whenever I think of another thing that always comes into my head is if it's a product company, patents, trademarks, all that kind of stuff makes sense. But there's a bunch of service companies, and not so interesting. Is that a fair statement too, or is that kind of a myth? Is patents, trademarks useful for both types of companies?
So it depends on what the short answer is yes, but now it depends on what is the service company that you're going to be creating. Okay. In other words, is it a restaurant? Is it a medical provider? Is it a dry cleaner? Is it a lawn care company? And so a lot of times there's a lot of different aspects, and everything is, or is it Netflix? Netflix is also a service provider in the sense that it's a streaming platform and service that you can watch videos on. And so, there are aspects of a lot of those businesses that have things that are patentable or that things you can capture. So across all of them, branding is something that you would protect with trademarks, and regardless of what is your business, if you're building a company that's sustainable and you want to capture it, I think branding captures all that across most businesses, including service-based businesses. But even now, let's say you take a couple of examples on the patent side. Well, Netflix has a ton of patents because they're looking to how to make the streaming better, how to to recommend which videos to watch, how you should make it so that it's a smoother, better process and better user interface. All of those are captured in patents. even on the, let's say you take now lawn care, and lawn care saying, oh, that, that's been around forever, is a pretty well established business, and there isn't really a lot of innovation going on. But one of the startups and small businesses I know and that I've talked with and worked with before, they created almost basically an Uber for lawn care. In other words, now people are able to sign up, they're able to register, they're able to find people and do the bidding process, and kind of in that application. Again, that's the patentable aspect. So even when you get into service, a lot of times as you're trying to compete in the marketplace to make things better, to easier, to innovate, and to otherwise, do something different than competition, it still very much lends itself to that patent side or that creative side and other things that beyond just the branding and the trademarks oftentimes will allow you to capture the value in other areas.
So I tend to, in my company, we do a lot of data and analytics, which is about helping empathize the data so that you can talk better to your employee. I shouldn't say talk better, more empathetically speak to your employees and get them engaged in the processes that you want them to do. Now, so since I work with a lot of companies like a lawn care company, a pest control company, people who've usually got lots of vehicles, that are going out to see their customers. So I think I heard something here. There's a lawn care company that's sort of innovated based on what they're doing in the industry and said, hey, we've built Uber for lawn care, right? And that is a process that they have created themselves. And they now said, hey, that's mine. And because of that, all of a sudden it went from something that, hey, there's just a website that you go and click on and say, hey, where are the slots? Where can I get somebody to come out and see me, for example? Now they can say, I own that. And if anybody from the outside wants to do that, they have got a challenge. There's a barrier, there's a gate or a fence that's been put around that process. And now, since that's defensible, that becomes much more attractive to others because they can't just get in. There's a moat around what they're doing now. Am I looking at that the right way?
Yeah, no, I think so. I mean, if I were to, let's say I were to take that lawn care business as an example, first of all, one is to create that system, to create, and I'll just call it the Uber for lawn care because it's an easy way to conceptualize. One is, it's an investment. You had to figure out the software, the platform, the back end, the user interface. You had to have programmers on it. You had to build it. You had to test it with your customers. All of which is one, you don't want, after you put all that time, blood, or money and effort into it, you want to capture that and say, hey, we don't, this is a competitive advantage for us. We don't want someone else to come along, see that it's a great idea, mimic it, and then all of a sudden, all of that time and innovation we put in is now being knocked off. And then two is, let's say at some point, whether it's the owner of the business or the investors are saying, hey, we want to be able to make an exit. We want to be able to retire. We want to be able to acquire other businesses. And so now let's say I want to make an exit. Now you've actually got that tangible asset, say, because people come along and say, why is your business so different? Lawn cares are a dime a dozen. The 16-year-old down the street can start one and say, no, we've got this asset that's tangible that makes it so we actually have a much bigger user base. We have reoccurring revenue. We have a way that they can interact, and we have a much bigger staff, be it independent contractors and all those things. And so now look, we've got a much bigger valuation that allows you to make an exit because you've captured all that value that you've built into that system that you've innovated. And so again, it kind of goes back to one, it blocks your competitors from knocking you off, but two, it also allows you to capture that value so that you have that within the business.
So it seems we've been talking about this idea of, even that lawn care company in this case has created a product of sorts, right? Mm-hmm. It doesn't always have to be a product, though. I guess what I'm saying is, or the question I'm trying to get to, and I'm not articulating it very well, right? Sure. Is a company, does it have to be a product always that you patent or trademark? And maybe that might be worth spending some time kind of differentiating. I've heard of there's copyrights, there's trademarks, and there's patents, and they all have different purposes. Let's start there. Can you kind of break those apart, and why do they matter?
Absolutely. No, I think that's a great kind of level set as to what you might be considering, because depending on your business, you're going to have different needs. So backing up even one step further, so there's a term that's called intellectual property. We've mentioned a little bit about it, and that is really the umbrella term. So it has kind of a few different things underneath it that are covered under intellectual property, which are patents, trademarks, copyright. So a lot of times intellectual property, they might be talking about one or all of those. But intellectual property, patents, trademarks, copyright. So patents are really going towards something that is innovative, so that's creative, that has a utility, has a functionality to it. Those are going to be captured under patents, and that's typically, it can be hardware, it can be software, it can be electronics, can sometimes be food products, it can be pharmaceuticals, and so there's a pretty big swath which it covers. And then second one is going to be trademarks, and trademarks are going to go more towards a brand, something that's for branding. So if you think of a name of a company, name of a product, a logo, a catchphrase, those type of things on the branding side are going to be one that just falls under trademarks. And the last one is going to be on copyrights. And copyrights are going to be more on the creative side. So something that has that creative nature to it. So a picture, a sculpture, a book, or a video, a podcast, all of those can be, or viral video, all of those can be on the creative side, are going to fall under copyrights. And so as you're looking at your business, which one do you, or, what is the value of your business, or what should you be thinking about protecting, and where does it fall under? Well, kind of depends on what your business is. So if you're to think of, hey, if we're really a great branding business and we make, we have a great sales team, we have a great brand, people trust us, then you're going to want to protect that with trademarks. You're going to want to protect that brand that you put all that time and effort into marketing to get your name out there and differentiating yourself. On the other hand, if you are a really innovative company and you have a lot of things that you're creating, cutting edge, different than what's out there, and you're saying that's what we are, we're a product company, or we are a creative company, then let's protect that with patents. And so you look at patents are for inventions, trademarks are for brands, and creatives are, or copyrights are for creatives, and that kind of gives you a good framework within which to determine what you might want to look at as far as protecting and growing your business.
So I'm going to talk about myself a little bit here, just to ask a question, right? So, what we've been doing as it's foundation, based on some foundational technologies, right? We've created a process to go on top of that. It's a market's not really a market until there's more than one player in the market, right? But I want to carve off my own little niche, right? So whether it's a landscaping company, lawn mowing company, or in my case, a technology company, there's a market out there, number of players in that market. I want to carve out my own little niche, and I say, I own this. So even as a landscaping company, even as a pest control or technology company, just saying, here's my process for treating my customers, for example, or my process for getting them from point A to point B. Is that process something that's worthwhile for companies to take a look at, and maybe in those three cases?
It's going to depend on what the process entails. And so, as an example, some people will come and say, hey, I've got a great training process. I've got a great way that we can teach people. And, a lot of times where I hear this is a coaching program or a sales program. They'll say, hey, we figured out a great way to teach people how to be a better salesman or how to be a better coach. And so here's a process as to how you might do that. And they say, now I want to protect it. Well, generally, those type of processes or methods are not protectable. And the main reason being is one of the standards for patentability, and there are really three, is that one, it has to be novel. Novel basically means nobody else has previously invented it. The second one is going to be its obviousness. And that basically means you can't take a couple things that are already out there, combine them together and call it a new, because really just putting in there are a couple things already out there together in an obvious way. The third one that is going to be what's called abstraction. And abstraction basically means what you're not able to patent is something that you do in your head or on pen and paper, and people have done it for a while, and now you're just trying to capture it and do it and get a patent on it. And so oftentimes when you're getting into training programs or coaching or those type of processes, those ones aren't going to be protectable. On the other hand, if you're just saying, no, what we're doing is we're taking a normal system, maybe it's been out there for a while, but now we're doing it via a computer, and we're doing it incorporating in analytics, we're doing AI or machine learning, and we're making it more efficient, better, less prone to error, and some of those things. So you're infusing more of the technology in the process, or you're otherwise building it out. That infusion of the technology and how you're applying it in order to make it better, those are protectable. So it kind of depends when, especially in the service-based business, some of those things simply really, other than branding and, curating a brand around it, but the actual system or the process may not be protectable if it's something that's really just more of a training process or plan. But if there's more of that infusion of technology within it, then you can protect it via patents.
So, I mean, look, I've always thought, and this is probably somewhat erroneous the way I think of this. I've always thought of whenever I think of law and lawyers, I usually think of risk mitigation, right? But I mean, what I heard from you early on, there's opportunity here as much as they're offensive as much as they're defensive, right? Is it something that every business should consider that they need some mix of copyrights, trademarks, and patents in order to be able to run a sustainable business? Is that the way you would think about things?
It depends on the business is the
Okay.
short answer. So, let's say sometimes you're going to need all three, sometimes you're going to need one, and sometimes you're not going to need another. And they're really where I'd step back and say, what is the core value of your business? So give me an example of a company that probably doesn't need any of them. If you are a local business, what I call mom and pop shops, and I love mom and pop shops, and I think they're great, but they're probably not innovating anything. They really don't have a lot of creatives, and their brand is really just the local people that they're serving in their area. They don't need a trademark either. And so in that case, you really don't need anything. If on the other hand, you're the next Apple, you are innovating things, so you're creating new products, you have a very strong brand and a reputation, and you are also creating a lot of content and video that is going to be valuable, whether it's commercials, whether it's on your website or anything else, then you need all three. So, and now let's say, or you're a restaurant. Let's say now again, you're a restaurant, you're the next McDonald's, you're going to go nationwide, you're going to franchise. Don't really have any innovations. Don't really have you may have some creatives, you may have some content you're putting out there, and you're definitely going to have a brand that's strong, and you're going to want trademarks. So it depends on what the core of your business is, where the value is, and what you want to capture is to what you're doing. Because in all three of those examples, mom and pop shop doesn't need anything. Apple needs all three, and McDonald's needs a couple. And so it varies depending on what your business is.
So, I mean, what I'm hearing here is kind of just distilling some of that is that it's all about intentionality, right? Where you're trying to go with things. If you're trying to go somewhere, then this understanding how you can protect your IP has a lot to do whether you'll be able to get there in a protected fashion or not, right? When do people usually come to you? I usually think people reach out to service providers. They reach out to people who've got expertise in the area when they've got an ouch that's been bothering them for some time. What is the ouch that they're having where they pick up the phone and say, I got to call Devin?
Most of the time, hopefully, you're not getting to the ouch factor, because that's usually now you're getting a cease and desist letter. You're getting someone that's saying you're infringing on their intellectual property, and that's usually the ouch. And so if you're at that point, we can help you, but it's usually much better to come to us and to get things in place well before you get to that point. And so typically there's a couple times. One that I wouldn't recommend, but there are people come to us. And then the one time that I'd recommend is, sometimes you'll have the people that are the perpetual, idea guys that always have something new and always they're looking for it. They never really actually implement on it. They never actually go anywhere, but they want to, they are kind of what I say, the get rich quick kind of scheme where they say, well, I got this great idea. I don't want to put any effort into it. Don't really want to build it, but I want to do is just get a patent on it and then go get a license on it. And 99% of the time, those businesses don't go anywhere. One is the misconception is if all you do is have a good idea and patent it, you're going to be rich. It's 99% of the time, it's not the case. Maybe there's that 1% that somebody can point out there that I'm sure there's always the exception to the rule. Those are not the times that you really want to do it, because it's almost always not a good investment. And I don't recommend doing it. You need to have a plan in place for building a business. Where you typically get it, and if I say, kind of your question is the ouch factor, but really it should be when you're getting to the point in your business that you built enough value into it that, if somebody were to come along, they were to copy it, they were to mimic your business, they were to take what you're putting out there, and it were to have a negative impact on your business. In other words, now if somebody were to come along and knock off your product, you're going to say, well, now we can't sell our products, or undercutting us on price, that's going to hurt us. Or somebody were to come along and copy your brand, and you say, hey, this is a big deal. We put a lot of time, money, and effort into building this brand. Before you get to that point, but as you're approaching yours, you're saying, hey, we're starting to build that value into the business. It's starting to get to that point that we will the next year or 2 years or not have that value. That's when you're going to want to approach an attorney. And that's where we typically are helping businesses. They're saying, hey, We have more than idea. We've started to implement on it. Maybe we have a bit of investor dollars. We're putting our own money in. We have a plan in place. We know how we're going to tackle the market. And now we want to be able to go out and build that business. And you say, okay, let's make sure to get those protections in place. So as you go and put all that time and effort into it, that you're not going to have it. By the time you're getting to hey, we've got a cease and desist letter, or somebody's come along and told us that we infringe on their trademark, or that they already have what we are selling is already patented, that's not a good situation, because you're much more on the defensive. Now you're having to react to it. And most of the time, if you're in the wrong and they are right, you're going to be paying a lot more to try and go fix it if you even can. So usually don't go too early where it's just the idea. Don't wait until you're getting the nasty letters from another lawyer, but kind of get to where you're starting to build value into your business and you have that plan path forward as to when you should go out and start to look to protect it.
So one other thing that I've heard this before, and I'd love to hear your kind of thoughts on this. Mm-hmm. I haven't been in the technology space for some time, in and around building software and technology, various technologies, some software, some hardware. I've heard from people, there's this idea of work product versus intellectual property, stuff that's sort of the secret. I mean, because once you put a patent out there, you kind of declare this is what it is. But if you just kind of keep it in sort of the skunk works where no one ever hears about it, that's another strategy. Does that make sense? Give me more color around that in that level of thinking. Does that make sense? That idea?
Sorry, say it one more time. Maybe I didn't quite follow. So go ahead.
So people, I've heard from people, and I mean, I don't know if this is a myth that makes any sense. I'm not smart enough to understand. It's the idea of that if I create a patent, it's now public record. It says, here's my system, here's how it works, and here's all the parts and pieces, and to some degree, how it all fits together, right?
Sure.
So insert tab A into slot B kind of thing, right?
Right.
But I've now shown others how to create tab A, slot B kind of connections, and they can't do exactly the same thing, but that kind of gives them a foundation to build something. Mm-hmm. The other side was just don't expose it ever at all, because once you put it out into the public domain, everyone else knows about it. Does that make any sense? That kind of argument?
I get the argument. I wouldn't recommend it. So with a very rare exception. So the first part, yeah. So when you do a patent, you're going to disclose a lot of the details of your invention, and that is a trade-off. And basically the reason patents are set up, in particular the patents, is it's almost a trade-off with the governmental system. They're saying, in exchange for you disclosing basically all the details of your invention, you get a 20-year exclusivity on that invention. So nobody else can come along and copy it, and you have legal rights that protect you. And so they are saying now the reason that they are motivating you to provide those details is they're saying now once you hit the end of those 20 years, this becomes public knowledge, and we want to incentivize people to add on and to continue to create and make whatever your product is better. So give you an example. Let's say you were the first person to come out with the black and white television. First television out there ever. Everybody wants it. They're buying it up. It's an awesome invention. And you go and get a patent on it. You disclose all the details. Because you disclose all the details, somebody else says, oh, that's awesome. I love the technology. I think I can make it into color television. So now they build on what you have and they go and create a color television. Well, now you just push things forward. You made it better, and you've improved the overall product, and the innovation is out there. Now, for those 20 years, if they build on top of your product, in other words, if they take your black and white television and build on top of it, or utilize that technology, they would be infringing your patent, and they either have to get a license from you, they have to collaborate with you, they have to pay you for it, or you can control it and say, hey, you have to wait 20 years. And so it gives you that control. Now, if on the other hand, you just keep this quiet and you keep it as what are called trade secrets, and you just don't go and tell anybody with the public. First of all, people are smart, businesses are smart. If you put your television, and I'll just keep using television, if you put down the public, and engineers are going to be able to open it up, figure out how it works, what you did to put it together, and now you have no protection. Because if they figure it out, if you're trying to keep it secret and somebody else figures it out, they are within their legal rights to go and rip it off, copy it, make it exactly how yours did it, because they're not infringing. You don't have a patent, and they're not infringing your rights. So you run a big risk if you put it out there and in any way people can reverse engineer it, or they happen to just figure it out a different way on their own. Now you have very little protection. So the only time that typically keeping it a secret is if it's like, Pepsi or Coke. If you take Coca-Cola, there, at least according to myth, but it's a pretty verified myth. And so I'd say it's more like a very high likelihood. There's only two people on the planet at any given time that know the full recipe to how to make Coca-Cola. And it goes so far as to, if one of those people passes on the same day, supposedly, they don't share it out to the public, but if you read the myths, supposedly the same day they pass it on, there is a ceremony to pass it on to the next successor. So the next person, the same day as the last person died, gets to know the recipes for Coca-Cola. They go to an excruciating amount of pain and effort to keep that secret to the point that nobody knows it. Even when they've gone to lawsuits and they've had people that have tried to force a course to do it, they fought those lawsuits tooth and nail because they're keeping it secret. Because as soon as it's out, as soon as people know the formula, they've lost all their value. And so the problem is yes, you can keep a secret. And if you want to go to those painstaking efforts and you have a motivating reason, by all means. But most of the time, for the vast majority of companies, you're better to get that protection in place, have that trade-off with the patent, get the exclusivity and go that route. And so you're not having to safeguard against everybody else trying to figure out what your product is, especially if it's one that's reasonable to reverse engineer.
So let me repeat that back to you. What I'm basically hearing is this idea that you can keep it a secret. Sure, absolutely. And you're always going to be constantly going around policing whether people are doing it on your own behalf, right? Whereas if you put it in government record, in public record, that this is what I've built, at least you get 20 years that the government's out there on your behalf also saying, well, you can't do that. So you kind of get you get the government on your side for 20 years at least.
Yep. And so there's always trade-off. And if you're Coca-Cola, I would recommend you do trade secret. They've been around a lot longer than 20 years. They have their trade secret. They have been put a ton of systems in place and make sense. But on the same time, if it was Apple and the smartphone, and all I have to do is open up the case, see what they did, or what all the electronics, how they all engineered it, and I'm able to reverse engineer it. Guess what? I can go into China or anybody else and have them make the exact same thing. It'll be out within a year, and I can reverse engineer it. So as much as Apple would want to keep their secrets in place, I don't even think Apple, with all their money, could keep it from people, because they put out their product in the market and people are able to do it. So you have to decide what the trade-off is. But for the vast majority of people, getting or trying to keep it as a secret isn't going to work.
The process, I think another at least thought that comes to mind, or it has come to mind in the past, is that when getting a lawyer or an attorney to start working something on something for me is the cost, right? Mm-hmm. And the idea that, I'm gonna throw some good money at this, and a good amount of money. Is this something that can be done in phases, or is it something that once you're in, you're kind of into this? How does that whole process work?
Yeah, I mean, and it's a pretty broad question in the sense that the cost to do a copyright versus a patent is pretty different. And as an example, our flat fees, if you're to file a copyright application, talking about $350. To file a patent application, you're talking about $6,500. And that's to get it filed. And so there is a difference in cost. And so depending on where you're at, you're looking at a different size of investment. Within that, there are some ability to phase it out. So copyrights really is less inexpensive enough. You're just going to file it. Trademarks are going to be kind of in that same realm. They're a bit more expensive, but you're usually, to file a trademark application, you're around $1,000. And most of the time, I would say, if it's a business that you're going to invest in, you're going to work to grow, and you're going to invest in enough to make that brand worthwhile, that's a cost that you should anticipate or to build in there. Patents do have kind of one option that allows you to spread out the cost a bit more, which is called a provisional patent application. So a lot of times, if you go online, you'll say, what's the cheapest way to get a patent, or can I do a patent yourself? And it'll pop up saying, do your provisional patent application. What a provisional patent application basically is it's a less expensive, informal application, doesn't have some of the as stringent of criteria, that allows you to go out, get a 1-year placeholder application that gives you patent pending, gets you date of invention, disclosure detail, and then gives you a year to decide whether or not you want to pursue a full patent and go through the process. So it does allow you to space that out a bit over time. Now, on the idea of should you draft it yourself, I don't recommend it. I mean, on all the legal things. Now, if you don't have any money in your startup and you're saying, hey, my options are either I don't do anything or I do it myself, then sure, go do it yourself. Now, the analogy I typically use is, people will say, well, hey, I can go watch a YouTube video, or I found this article online, or I read these, and they say, hey, it's not that hard. I'm sure I can figure it out. And the best analogy to probably can give is, let's say you need a shelter over your head. And you're saying, okay, I'm out in the cold, I'm out in the rain, I need something to keep the rain and the snow off of me. Well, without really having much of a guidance, you could probably pitch a tent. You could figure out how to do it on your own without any help or from assistance. And so you'll have shelter over your head. Now, not going to be very comfortable or big, but you do have shelter. Now, let's say on this is the next, I want to do something where I can go buy a DIY course or read about it online. I would say that's the best thing is let's say you went and watched a YouTube video on how to build a house. At the end of that, you probably have a house that you have built. It's not going to be very comfortable, but it's going to probably be slightly better than a tent, and it might last a little bit longer. Now, on the other hand, if you wanted to go and have someone else that actually knew what they're doing, so you wanted to have electrical, you wanted to have plumbing, you wanted to have heating and air, you wanted to have insulation and windows, and you wanted to have all of the niceties of it, then you're going to go hire someone that is experienced and knows what they're doing. And that's why you're going to go out and hire someone to build your house. And that's a lot of time the same with the legal aspect. You can go out and do it yourself, have no other experience, and file something. You can go do a DIY course that gives you some, YouTube videos, or DIY course that gives you some guidance, or you can actually go out and have an attorney do it. Now, again, just like that analogy, if you don't have any money and all you can go buy is get a tent or make your own tent, yeah, do that, because it's better than not being out in the cold. But if on the other hand, you're saying, hey, we're investing in this business, we're going to make it a success, it's going to be we have a plan, we're going to bring on investors, or we're going to put in our own money, then it'd be like, hey, we've got the money, we're going to do it. Then go out and get the professional that's going to get you the house that accomplishes your goal. So know your goal, know what you're trying to accomplish, and then see how, what of those options are your best ones forward.
Someone used a quote that I do like using, and I think that's what I'm hearing here is if you pay peanuts, you're going to get monkeys. Right? I mean, it's if you want to do it yourself, expect to do it yourself level of protection, I guess, right?
Right.
And strength. But if you want someone to really kind of peel back the layers of the onion and write it the right way, it's going to take some time and effort.
Yeah, and that's true with all business, right? In the sense that if you want to go start a business, you're going to have to do a lot of time, money, and effort and work, and probably invest in it a bit, and otherwise get it up and going. And just like if you're going to put out a product, you want a good product that's worthwhile, that you can stand behind, that people are going to want to buy. You need to have the other aspects of your business solid. And now it's always a balancing project, because as a startup or a small business, you always have more things to spend money on than money to spend. And so you're always having competing interests, but now you're going to have to say, where is the biggest areas of value, and what do I need to make sure to have in place so that my business is successful?
So I feel like we've covered sort of a range of different areas of kind of looking at this. What are the things that you wish more people would ask in going through this process when they come to you and they say, they ask all the questions like I do, and then you say, yeah, so let me tell you two things that you probably ought to know. What are those things?
The thing is, I would wish that more people would ask questions. In other words, get it. I would, one of the things that oftentimes, and you kind of hit on it a bit earlier on, that a lot of people just simply are scared off because attorneys are going to be expensive, and they worry that they're going to go sit down with an attorney, they're going to charge them as soon as they start walking in the door, and they're going to just say, hey, I can't help you. And now they spent all this money that they didn't really want to, and they didn't have any value. Go find an attorney that will spend, and we do it, and I know other attorneys or some other firms do. You go find an attorney that will take 15, 20 minutes to sit down and hear about what you have to say and get some guidance. So a lot of times people push that off way too far, and then they create other issues for their business. Give you an example. One of the things that people aren't or typically aware of, and particularly with patents, is that once you put your invention, let's say you had a great idea, you build it, your MVP, your minimally viable product, you put it out in the marketplace, and you have a year from which you can actually file a patent on. Meaning, if you put it out in the public, you wait more than a year, you've not just donated to the public, you're not able to get a patent on it, and anybody else can do the same thing you are. And so the drawback is a lot of times I'll have clients that come in the office, and the conversation will go something to the fact of, hey, we've been in business for a couple of years, and we finally got it to the point that the business is making a bit of money, and we're being profitable. The product is catching on, and we're really, we push it off, for a while, but now we're wanting to go about getting a patent on this to make sure it's protected, because we're seeing a few competitors are starting to kind of encroach in our space. Then I get the less than fun conversation of saying, well, that's awesome. You have a good business. I'm excited that it's going well for you and you're making some money. Unfortunately, you're not able to get a patent on it because you've been out there for over 2 years and there's that 1 year rule. And so a lot of times it's more of the questions that people don't even know, to the fact that they're missing out on deadlines. And now they've created issues for the business to where, hey, I put all this time and money in getting the business up and going. And oh, by the way, now my competitors are knocking me off. I have very little recourse to do that. So it's usually more of the things they don't know as opposed to the questions they don't ask. And so knowing the deadlines, and even if you're getting going and you're saying, we don't have the money today, but we want to make sure that we have a plan in place, understanding what the deadlines are, what the costs are, and building that into their plan and their strategy down the road, so they know when those landmines are and when they might be tripped, is going to be the thing. And I know that's a bit of a different answer to your question, but those are probably the things that I wish people would know, that if they did, that they would, or a lot of times, avoid those issues that their people hit into down the road.
Let me ask you another question here, and that is, lots of times I find that when people are evaluating it based on cost, they don't truly understand the value, right? I mean, an example, I love racing cars, and I can tell you the difference between a 87 octane gas and 91 or 92 octane gas, because my car performs differently with that different gas. But I don't think the average Joe out there actually knows the difference, because it doesn't matter to them, right? So let me just get the 87 as opposed to 91 because it costs 14 cents cheaper per gallon. By the same token, if someone comes to you, it is really difficult for someone who is not an attorney, who's not gone through this process, to really evaluate, is this, I think a lot of people always think of things in terms of thumbs up or thumbs down, and there's nothing in the middle. There's lots of shades of gray in most everything as an adult I can think of. Mm-hmm. How do you usually ask people to evaluate success, or kind of move in the right direction? How do you get them to give them a sense of, hey, look, we're going to do right by you, and here are those milestones that you'll see, or those markers of success?
Yeah, and if I were to maybe read into the question just a bit, one of the things probably is, how do you know whether you have a good attorney, or whether or not it's well to select them, right? So, and that because there is everything from the cut rate attorney that is going to do the very basic minimal job, or sometimes not even do a good job at all, and that they're very lowly priced, and there's a reason why they're lowly priced. And then you're also going to go into, and I worked for some of the top, AM Law and top 100 firms, and they were at the top of the mark, and they charge as much as anybody else out there. And you're saying, okay, I've either got these, and what's the difference? Well, there is a difference, and sometimes you're paying for the value, and there's a difference, and sometimes you're paying for the nice building and the big cars and everything else. And everybody wants to pay for the value. What I would recommend is finding the attorneys that add that value, that you're getting the same or end product and result without having to pay for a whole bunch of partners, the high-rise building in downtown, the wood-adorned offices, and all the Lamborghinis in the parking lot type of a thing. And so, how do you go about doing that? And probably, it is difficult, especially if you're getting into an area that you're not as experienced, you haven't gone through it as much, to understand whether this is a good attorney, or I'm getting good value, whether I'm getting taken, or whether they're providing me a really terrible value. Probably the best indicator that I found as far as finding a good attorney, whether it's an IP attorney or really any attorney, is, are they taking the time to explain things to you to the level that you understand it? And the reason being is, if if they're the cut rate attorney, they don't want to explain it to you, because they don't want you, if they explain it to you, first of all, if they know how to or what to explain, then they're not going to want you, because then you'll understand that they're not doing a very good job. On the other hand, if it's the attorney that's going to be super expensive, that's just going to want to get as much money out as they can, they're not going to want to take the time to explain it to you, because they're going to want to have you come in, give you all your money, and then have you out the door as quick as they can, because they're all focused on the dollar. And you want somewhere in between, which is an attorney that is saying, hey, let's sit down, let's explain, what is the process, what is going on, why are you needing these things, what do you need these things in the first place, what would you recommend, how would you do, this is how I would do it in my shoes. And if you can kind of find that attorney that doesn't, they're not going to spend hours just training you on everything that they know. That's why they went to law school and why they have the expertise. But if they can spend at least an amount of time walking you through, helping you explain, that's really as good a time as you can find. It's that value. And then you're finding that attorney that's going to give you just as much as a high-rise big attorney's firm, that you're paying a whole bunch, but at a more reasonable price, because they're not paying for the overhead, they're not paying for the big buildings or the Lamborghinis. They're just trying to provide the value at a reasonable rate and looking to help you out. And so it's not an easy thing to gauge and balance, but that's probably the best thing is if you're either not willing to explain it to you, or it's so convoluted and hard to understand that you're not going to understand it, you probably need to find a new attorney.
Yeah, that's interesting. You break it out that way because I've spent a lot of time thinking about this idea. What does an expert mean? And to me, the definition, it may not be the Merriam-Webster type definition, but the way I think of it is an expert is someone who's done it 1,000 times and they can do it 1,001st time with their eyes closed. But that's expertise. Where I want to hire that expert is when they can say, yeah, so let me break it down into, Albert Einstein said, if you can't explain it in one sentence, you don't truly understand it. So that person who can say, so here's what's going to happen. And you say, I got more questions. Fabulous, right? That's the kind of relationship you want, not someone who says, here's one sentence. Here's an invoice for $2,000.
Now let me start charging you for every word after that one sentence, and then because the other thing you can find expertise, now find someone that's expert that has done it a while. Don't get me wrong. You don't want somebody that this is the first time they've ever drafted a patent and you're the guinea pig and they don't have any experience, but. And expertise should be inherent. If they've done it for a while, if they've understand it, then you're saying yes. You don't want somebody that every time that you call them or give them or shoot them an email that you're questioning whether or not you should reach out to them because they're going to charge you that or $500 for that 2 minutes that they spent on the email because they're rounding it up to an hour of their time. It's not going to be a good experience, and you're not going to even understand what you're doing, why you're doing it, or what the process or what's going on. And you're going to be so afraid to ask because you don't want to get charged. And so it just creates a not a good relationship. And so you're looking for someone that's saying, hey, I have the expertise, I have the ability, I've done this several times. And then not to mention that I also am having that heart of a teacher where I want to make sure you understand it such that you now have that value that's conveyed to you. Because if you can find that sweet spot, then you're going to have that good relationship. You're going to understand what you're doing, why you're doing it, what it's going to cost, and what the process is. And so finding that balance is really what you're looking for.
So many service providers with professional service providers like the lawyers, there are only certain areas where you can practice. Is that a limitation here in terms of copyright, patent, trademarks? Are there geographical limits?
So there's two different limitations. So one on the patents, patent attorneys, and different than copyrights or trademarks, but just for patents, there's a special little test that we got to take, which is called the patent bar. So every attorney has to take a state bar exam, whatever state you're in. If you want to be a licensed and practicing attorney, you have to take the state bar. In addition to that, if you want to be a patent attorney, they have a second bar that you have to go and take or study for and pass in order to be a patent attorney. So in that sense, there is that additional limitation where not every attorney you go into can be a patent attorney. They have to have that specialized and additional license and passing that test in order to do it for you. If they tell you otherwise, they're lying, and go find a better attorney. The second thing that you're going to want to do is the nice thing with patents, copyrights, and trademarks is they're all on the federal level, meaning that it's not state specific because the federal is across all of the 50 states. And so as an example, with my firm, Miller IP Law, I have more clients outside. I'm located, they're headquartered in Utah. We have more clients outside of Utah than inside of Utah. I have clients that are California, Oregon, Washington, New York, New Jersey. I'm sure just about every other state I can think of. And, it makes it nice that you don't have to worry about it being state specific. Look for the value of the attorney as opposed to the location that's the one that's down the street and closest to you. Now, if you have a great attorney that's nearby you and closest to you, they're down the street, great, go use them. But the nice thing is that you can expand your horizons to look for the attorney that is going to provide the best value and the best expertise, not the location that is nearest to you.
Well, we're kind of coming to the tail end of our time. I wanted to do a little summary of kind of the things I heard and make sure I learned some things out of this. But if anybody wants to get in touch with you, what's the best way for them to reach out and get in touch with you?
Sure, absolutely. So I'll give 3 different ways that they can reach out to me depending on how they want to connect up with me. So we, as I alluded to, we do, along with some other firms, but we do a one-on-one free 15-20 minute strategy meeting where we'll sit down, talk about what you have going on, what you might want to consider, and what might be the next steps. Easiest way, if you want to schedule the one-on-one strategy meeting, is just go to strategymeeting.com. That links right to my calendar. It's an easy way to grab some time with me. So strategymeeting.com for the one-on-one. If they want to just find out more about the law firm, we have almost everything on flat fee pricing so you can understand the pricing easy, straightforward. We have a ton of educational material. We have video, we have blogs, we have a podcast, we have a YouTube channel, we have all the content across just about any way you can or you want to learn. And if you just want to go to our website, it's lawwithmiller.com. And that takes you right to our website. The last one is if they want to connect up with me with socials. I'm not that active on Facebook. I know I have a Facebook account. I'm not that active on Instagram or others, but I do enjoy LinkedIn. It's the place where I tend to like to hang out because it's a lot more business related. If they want to connect up with me or check out my profile on LinkedIn, just go to meetmiller.com and that'll take you right to my profile. So strategymeeting.com for a one-on-one strategy meeting, lawwithmiller.com if they want to check out our website, and meetmiller.com if they want to go to connect up with me on LinkedIn.
Thank you for that. Couple of things that I think I've learned here in our conversation is, number one, that copyrights, patent, trademarks are not always about defense. It's also about offense. It's about potentially monetizing the processes, the value that you create as a company that is now publicly defensible, right? So that you can say, that's mine and nobody can take it away from me for at least 20 years. You can build the tent version or you can build the Xanadu version. It's really up to you. The tent version will at some point in time fall apart. The Xanadu version will probably be something that people look on for a long time. It's really just what you want to do and what your appetite for risk is as to how you want to do it. And the way to find a good lawyer or an attorney who can help you with this is really someone who's going to take the time. And I think I completely agree with this. Finding somebody who can take the time and demonstrates expertise by making it as simple ways that you can digest it, the pill, to say, this is what it is. Here's how it works. Can answer further questions. Did I get that mostly right?
Yeah, no, I think that was a great summary and some great takeaways. So I couldn't have said it better myself.
Well, anybody who listened in, I got so wrapped up in the conversation, I didn't actually even stop to ask for comments throughout the course of this because I was sitting there kind of taking mental notes the whole time. But thank you for listening in. Hopefully you got some nuggets out of this. But more than anything else, hey, Devin, I appreciate you spending some time with me.
Hey, it was my pleasure. It was an awesome conversation. Appreciate you having me on.
Yeah, thank you. Look forward to talking again soon.